Well, good morning and welcome to this webinar from Solidus Independent Estate Planning. We're the legal partners of your financial advisors. That means that we work with them in drafting most of the legal documents that you might deal with, whether it's your wills or whether it's a trust or powers of attorney or share purchase agreement, virtually any legal documents. Those are things that we deal with through your advisors. So today, in this webinar, which will last probably 25-35 minutes, something like that, I'm going to cover planning which we should be thinking about for single people. By single people, what I mean is people who are divorced or genuinely single, or perhaps widows or widowers. A lot of this information is relevant for everybody, but that's the group that I'm really going to be focusing on today. Now, if you've not attended a webinar before, you should have, if you've clicked on properly, down the right-hand side or maybe left-hand side of your screen, you'll have a little control box. And in there, you'll see a section which says, hopefully, questions. And you can actually type questions to me as we go through. So as I'm doing the presentation, I'll be checking that. So if questions come up from people, I will bring those in. Now, what I can also do, I can also turn your mics on and off so we can actually hear you. But what I'm not going to do that today, simply because sometimes it messes up the quality of the recording. We don't necessarily want to hear the kids in the background if you've got kids in the house, that kind of thing. So if you do want any questions answered, just type them in the question box as we go, and I either do them as we go or I'll do them at the end, depending on how things are. So I'm going to switch over. So I'm going to switch over to my screen now. So what you'll do is you'll see my screen. I'm going to run a presentation. I'm going to use the presentation to talk through various things for you. So that should give you my screen now. And then I will just run this presentation and we'll talk through things. Here we go. Okay, so as it says there, my name is David Batchelor, and I'm one of the partners with Solidus, and I've been working with Solidus probably 15, probably closer to 20 years, I would guess. And within the company, my main role is working with our individual licensed advisors. Your advisor who passed this link on to you is a licensee of Solidus, and they have to be accredited by us to be able to use us. And so the fact that you've got that advisor who's accredited by us means that they're already a step above most other advisors, because that means they've had to go through certain training that we put in place in certain things, which mean that they understand some legalities with regards to the law and not just financial planning. So today I'm going to focus on 4 areas. First of all, I'm going to talk about capacity. By capacity, I mean your ability to do things, whether it's legal things, whether it's financial things, that kind of stuff, and the things you should be thinking about now. Then I'm going to talk about your will, how a will should be structured, and whether or not you should have one. Then I'm going to talk about inheritance tax, not for a great deal of time. I'm going to focus on inheritance tax a little bit. And lastly, I'm going to talk about your beneficiaries. Who should be your beneficiary and how you should pass money down to them, what's the most effective way of dealing with them. Now, as you type questions, I will just use your first name. So if you want to type questions, then that's fine, because we've got a fair number of people on the call, but just type the questions and I'll just use your first name, not your surname, because we have about 4 Davids on the call, a couple of Traces, and that kind of stuff. So so not everyone knows who you are. But then at least you can identify that was you. So let's start about this thing with capacity. And what do I mean by capacity? Well, by capacity, what I mean is our ability to actually get things done. And under English law, you must have capacity to transact transactions, whether that's to buy a house, whether that's to open a bank account, whether that's transfer money. And what we really want to be doing as a single person, probably more than anybody else, we need to protect that capacity, because there'll be certain situations where you will lose capacity and you need to protect yourself, particularly for these 2 areas. One is with regards to your health, and the second one is with regards to your wealth. Now, what I mean by that with regards to losing your capacity, this can happen in various situations. The obvious one is, if you perhaps have an accident and perhaps you're in a coma. That's the obvious one. But there's a lot more ones which we think about. So let's say you are one of the unfortunate ones with the coronavirus that's happening at the moment, and you ended up in intensive care. You would be incapacitated. It's highly unlikely that you would be able to perhaps make decisions or deal with the money that you've got. So if the stock market's crashing through the floor, then you're not going to be able to do anything with it because you're going to be in intensive care. Likewise, you might not even be able to pass your intentions on to the doctors as to what you want, how you want to be treated, the kind of medication you want, that kind of thing. So your health won't be protected. So by capacity, you could lose that in many ways. In fact, I was speaking to a client I would say probably 3 weeks ago, who had actually been on one of these ferries, which was stuck outside of port, and they wouldn't let the ferry on because it was coming from France. So they wouldn't let the ferry into the country, and so they were incapacitated. They just couldn't do anything because they were stuck in the sea somewhere, not being able to get to port. So this can happen at any time. Now, the way to protect yourself as an individual is to have a document called a lasting power of attorney, which most of you will probably have heard of. LPAs for short, lasting power of attorney. And this is where you give somebody else the ability to deal with affairs on your behalf. That other person is called the attorney, and a lasting power of attorney is where you give them the power to make decisions for you. And there's two types of power of attorney that we have in English law. And the first one is a thing called a health and welfare power of attorney. So this is where you give somebody else the ability to make healthcare decisions on your behalf. And you might not think that's particularly important, but my dad, for example, who's very poorly, and he was stuck in the house for maybe 18 months or so, long before we had to all be self-isolating. And his issue that he couldn't really speak. He found it very difficult to communicate by writing anything. He certainly could use a computer. Now I have a health and welfare lasting power of attorney on him. That means that I can go to the pharmacy and order his drugs. It means I can talk to his GP with regards to the medication that he needs and what treatment does he need. But if I didn't have the health and welfare lasting power of attorney on my dad, then I wouldn't be able to order his drugs. I wouldn't be able to speak to the doctor. It's a whole bunch of situations. When he goes into nursing care, which I'm sure he will do fairly soon, I wouldn't even be able to decide which care home he would go to or what sort of treatment they would have. But by having a lasting power of attorney, it does mean that I can answer questions and make decisions for him. And he's chosen me as his attorney because he expects me to act in his best interest. And in fact, that's the point of an attorney. You have to work in the best interests of the person for whom you are an attorney. Then you have this other type, which is a wealth lasting power of attorney, and this covers your property and affairs. So that pretty much is as it sounds. So it covers making decisions on your property, be it physical property like your house or perhaps your rental properties or something like that, but also your financial assets, your financial property. It covers those kind of things as well. And again, with my dad, I need to be able to access his bank account. So without lasting power of attorney, I can't get to his bank account and move things around and pay the bills and that kind of stuff. The lasting power of attorney allows me to do this. Now, the important point with lasting power of attorney is that we believe that it should be registered as soon as it's set up. Unless one of these documents is registered with the Office of the Public Guardian, it used to be the OPG, some people call it the Court of Protection, but it has to be registered, and that gives you the ability to actually use the thing to speak to the bank, to speak to the doctor, that kind of stuff. And this is why it's so important. And so everybody, I believe everybody, no matter what your age or whatever your circumstances, should have a power of attorney, someone who can look after things for you in the event of a difficult situation. And I can't think of any reason why not to have the thing. I really can't. One of the challenges that you do have, yes, there's a question coming here from David, and the question is, what about certification? Now, let me explain what certification is. When someone writes a lasting power of attorney, it has to be certified by someone who is able to certify it, obviously, that you understood what you were doing and why you were doing it. That certification has to be undertaken before it's registered at the Office of the Public Guardian, the OPG. Now, I don't know who would normally deal with that, but all of the advisors that we work with at Solidus have the power to certify powers of attorney for their clients. Because they have an existing relationship with you, they have the ability to tell whether you have capacity, whether you know what you're doing, whether you know the power of attorney, whether or not you're being influenced for them. So all of the advisors that we work with have the power to do that certification for you. More importantly, they also have the ability to put a licensed power of attorney in place without visiting you. There's been a relaxation of some of the rules, and certainly at Solidus, we've made it easier for advisors and clients to work with us so that they don't physically have to sign applications and the like. So your advisor can do this all with ideally with a video call, whether it's FaceTime, whether it's a Zoom call, whether it's Skype, whatever it is, or that can be done on the telephone, but a video call is probably the best way to get the information from you. So the first thing really that I want to speak about is this area of capacity. And so it really comes to this point of everybody should have at least a power of attorney, whether or not they have both documents or just one. That's really for them to decide, and that's something that you should probably decide with your advisor. But now I want to talk about the idea of will and how to deal with that before I'm going to cover inheritance tax and beneficiaries. And so let's start with this idea of a will. And the first question I want to ask is, do you have a will or not? Because if you don't, you'll have a situation which is called intestacy. And if you do, then you have the will, which processes what happen in death. So the first question is, do you need a will? And it depends who you want to benefit in the event of your death. And this is something which is by definition going to happen to all of us. You know, there's only, some people say only two definites in life, death and taxes. Well, I'd probably add change to that as well. So probably those three things that we know are always going to come across. And so it depends who you want to benefit. So imagine you don't have a will for whatever reason, or if you have a will but it's not valid, or it's out of date, or there's mistakes on it. If any of those things happen, then you end up having the intestacy rules rather than your will. And this is an important point to remember, that if you have a will, but your will is a document which has got mistakes in it, so it's thrown out by the court, or it's out of date. Most wills written prior to about 2016 are probably out of date now because of changing legislation back then. If your will is out of date, or there's mistakes, or it hasn't been signed properly or not dated properly, then you get the intestacy rules. So this is what happens if you don't have a will. And the first thing is, if you die without a will, then everything passes to your children in equal shares if you have them. This includes adopted children as well, but they all get it exactly split equally. And that can sometimes pose a problem, you know, if you've got the house and one of them wants to keep the house, the other one doesn't want to keep the house, or one wants to keep the house and rent it out, and the other one wants it sold because one wants the capital and the other one doesn't. This can cause all sorts of problems, I suppose, because it just simply says split everything up equally. I know that when my grandmother died, my paternal grandmother died, she had this little porcelain doll, and three of the grandchildren ended up arguing over this. Each one of them had said that Nan was going to leave it to them. But there was nothing in her will about this. This is a long time ago, long before I was in this business. And they end up all arguing over this porcelain doll, which is a really sad set of affairs. But that's what can kind of happen if you just pass everything to the children. But if you don't have children, then it's your parents that will inherit everything. So I don't know what age you are, but I'm in my mid-50s at the moment, and my parents are in their late 70s. So in the event of my death, if everything went up to them, that's fairly pointless, since it could bounce back up to them and then bounce back down to me again. So it's a fairly pointless activity. The other thing, of course, here is that if everything passes to your parents and they need care because they're much older than you, well, then the local authority is going to nab that money straight away, because it just increases the size of their estate. But if you don't have children and you don't have parents, your parents aren't surviving, then everything goes to your siblings in equal shares. So your brothers and sisters, if you have any, no matter what the relationship with them. Then after that, it goes to uncles and aunts and cousins. Then if there's nobody else in the family that can be found, then it goes to the crown, and the crown actually benefits. Now, if that's what you want to have happen in the event of your death, then you don't need a will, and don't go to the expense or the cost or the aggravation. But whoever is going to benefit, you should really explain that to them. Otherwise, they could spend ages searching for a will which doesn't exist. Now, the alternative to this is to set up a will, and we all understand this. And the big benefit of having a will is that you can decide who gets what and when. And this is the point. Yes, you can decide who gets everything, but also more importantly, you can decide when they get those assets. Now, if you take, for example, a couple, say a lady perhaps who is divorced. So I was speaking to a lady maybe 3 weeks ago who's divorced, and she has 3 children. He wants to pass the money down to the 3 children. But one of them she's already started to give some money to. So her daughter was buying a house, so she gave us some money towards that house, 30, 40, 50,000 pounds or so. So what she wanted to do is to make sure that the will took that into account. Now, if you don't write the will correctly, then they're all going to get an equal share, which means that the one who you've already given some money to is going to be getting more than all the rest. So it's really important to ensure that your will is up to date and takes that thing into account. There's a thing called a gift equalisation clause which can be written into wills, which balances those things up. And most wills don't have that that I've seen. And the other point which I made just earlier is that the rules changed certainly with regards to the way you pass an estate quite a lot in 2015-16, and so any will that was written probably I would say any later than 2016 is probably out of date now. So a fairly obvious point of view is that once you've got your capacity, so this is dealing with you now, make sure you've got your arrangements in place now, then is to make sure that you have a will which is relevant and up to date. Now, if you have a will that's relevant and up to date, there's 2 other things we've got to consider. One is there an inheritance tax that's going to be payable? Then lastly, who's going to benefit from things? So let me spend a few moments talking about inheritance tax and how that works, and then talk about ways in which you can deal with it. So inheritance tax works like this. You have an amount that you can gift. Every person has an amount you can gift, which is currently 325,000. You can gift without any inheritance tax. Now that's the amount that you gift on death. So anything over that is going to be taxable. But then we had a rule change on inheritance tax, which comes fully into force this April, which says that there's an extra allowance called the residential nil rate band, which for most people will be £175,000. That's £175,000 on top of £325,000, which means that the first £500,000 is free of inheritance tax when it passes down to whoever you're going to pass it to. Now, this does make some assumptions. The first one, for you to get this extra £175,000, you must own your own house and be living in your own house or recently lived in your own house. And for this also to count, you must have that house and you must pass it down to your children. Your children must inherit it. Now, what this means is that if you don't have children, I'm afraid you don't get that extra £175,000. It's only the £325,000 that escapes inheritance tax. And so for those people that don't have children, you're going to be penalised adversely and pay more inheritance tax just because you don't have children. Seems a little unfair to me, but that's the rules. Also, if you were to be renting a house instead of buying a house, you also don't get this £175,000. Again, that seems a little bit unfair to me. I've got a couple of people that I know who are in rented accommodation now because they sold their house. They wanted to move, but it fell through. But they wanted to keep their purchases. They sold the house, and they've been living in the rented house now for 3 years because they can't find a new property. And that means that they don't get an extra £175,000 worth of allowance, which again seems dreadfully unfair, but that's the way things are, I'm afraid. So if you have children, if you have a house, it's very important that your will clearly states that the house is going down to the children for you to get this extra amount of allowance that avoids inheritance tax. Everything over that is chargeable at 40% inheritance tax. So that means if you're a single person and you pass everything to the children and you're worth £1 million, £500,000 passes down to the children. The other £500,000 is charged 40%, so £200,000 is going to be paid in tax. But if you don't have children, or you don't have a house, that means everything over £325,000 is going to pay 40% inheritance tax. Now, if you have a house, and it depends where you live, but certainly if you were, say, in the southeast, there aren't many houses where you're not going to use up most of that £325,000, for example, in your allowance. And if you don't have children, then you don't get this extra allowance. That means everything over that 325,000 is going to be liable for inheritance tax. Now, when it comes down to inheritance tax, you've really got, I suppose, two alternatives. One is to don't care. Who cares whether there's inheritance tax? The other is to give it away. So if you ask this question, who really cares whether or not you pay inheritance tax? Because if you don't have children, you don't have brothers or sisters, you might say, well, perhaps it's fine for it just to go to the government. And if that's what you want, that's fine. But if you don't want to do that, then next thing you really got to decide is, if I don't care, then how am I going to deal with it? And principally, there are three ways to deal with inheritance tax. And it revolves around either giving assets away now or giving away in the future, or indeed shielding some of your assets. And this isn't an inheritance tax presentation, so I won't go into a lot of detail, but let me just summarize it, that the easiest way to avoid inheritance tax is through the use of legal trusts. And there are principally three types of trust. The first type of trust is a trust where you can give away everything absolutely and it's gone. And most of you will have heard of the 7-year rule. So at the moment, assuming there's no changes, then after 7 years, that's fully outside of your estate. There's a second type of trust where you can give assets away but retain the income. And then there's the third type where you can give assets away but retain the growth. So if you've got a bank account with £300,000 in it, and assume it's paying some interest, not it probably is at the moment, but let's say your advisor has set up some form of investment for you, which is generating an income for you, you can place those investments into a trust to retain the income, yet the capital falls outside of your estate after the 7 years, and that will save a huge amount of inheritance tax. So we've covered capacity, we've spoken about the will, and we've spoken about inheritance tax. Next thing I want to talk about is the beneficiaries. And by beneficiaries, what I mean is who's actually going to benefit from everything. And if you're a single person, a lot of the single people that we see don't have children, so it's about who's going to get what and when. But also, half the single people that we do estate planning for through advisors, where perhaps they're a widow or widower, or perhaps where they are divorced. And so you've got to decide who's going to benefit and when. And if we think about it, this is what most people will do. And let's, for this the purposes of this, assume that you want to give away to 3 people. Now, what you would normally do is you'll have a will, and it says, I give away to Tom, Dick, and Harry. Now, these might be your children, they might be not. For the purpose of this, it actually makes no difference whether they're your children or not. So you want to just give your money to Tom, Dick, and Harry. And so to make the example really simple, let's assume you're a very wealthy person and you've got £3 million. Let's make it very easy. So your house, your pensions, your investments, everything else adds up to £3 million. And so you want to give it equally in 3 ways, so they get £1 million each. Now, of course, that won't necessarily be the case because inheritance tax is going to be deducted. But for the purposes of this, let's ignore inheritance tax and let's assume that the £3 million passes down to each one, which is fine. The issue tends to come when we look at their other halves, because what most people seem to be concerned about, and if you're like most people, this will be a concern, when you pass money down to someone, then what happens if you either don't like the other person, perhaps it's the daughter-in-law from hell, or perhaps they've got involved with someone who you really don't think it's a good idea to be involved with. Because if you pass the money down, let's say it's to your son, and he's married to the daughter-in-law from hell, and I've certainly seen a few of those. If their relationship goes south and they end up getting divorced, then the daughter-in-law from hell will take half of that inheritance. Or indeed, if he dies, then the daughter-in-law from hell could end up getting all of the inheritance. And that's not what most people want. Most people want to protect it for the people that they are passing it to. And so the easiest way and the most appropriate way of doing that is to use a thing called a beneficiary protection trust. Now, this does exactly what it says on the tin. It allows the money to pass from the will into the trust. And then what the trust does is the trust passes it to the beneficiaries, and it protects those assets for the beneficiaries. Now on this shot that you've got on here, on this slide here, it shows one beneficiary protection trust, but usually I would set up one for each of the beneficiaries. So if there's 3 people, I'd have 3 beneficiary protection trusts, so each of their inheritances can be kept separately and they can identify who they are. So this is how I've got it set up for my children. I've got 2 daughters and 1 son. So I have 3 beneficiary protection trusts, and what they inherit goes into their individual trusts, and then they can access the money from those trusts. And the process by which you access it protects them. And what it means is that whatever they inherit is totally ring-fenced for them or anybody else who I've put or you've put into your trust. So with my trust, it says my daughters are the beneficiaries, and my son, but in the event of one of their deaths, it says their sibling will replace them, and after that it says their children will replace them if they have children. What it does, it totally ring fence their other halves, the people they've been living with, their husbands and wives and that kind of thing. And it doesn't mean I don't trust them. You know, my youngest daughter's married, and she's married to a lovely chap, really nice chap. And so the fact that I've got this trust in place is not a negative, because all the time they're married and happily married, he will benefit in the same way she will do, because she'll be taking money out of the trust to spend it on holidays, spend it on the house, or whatever it may be. But if the relationship breaks down, this is where the beneficiary protection trust comes into play. This is where it really protects things. And so you should never be worried about how your children or other people may think about it, the fact that you've set up a beneficiary protection trust. Some people get a little bit concerned that, well, if I set this up, my son-in-law will suddenly think I don't trust them. No, that isn't the case. And what it just means is you're protecting it for your bloodline, and there's nothing wrong with that. And this is where the advisors that we work with are very good at having conversations. Most of the advisors that we work with prefer to meet, certainly it'll be by video at the moment, with the beneficiaries to explain the purpose of the beneficiary protection trust so that it doesn't come as a shock. It's always very difficult for you who say setting up one of these things to explain it to your children or your nieces and nephews or your grandchildren or to somebody else, because it can look like you don't trust them or you don't trust the other halves. But that's just because you're not necessarily used to explaining it and don't understand how they look at it. And our experience is that when our advisors, the people that we work with, being their legal partners, when they have the conversation with your children, your grandchildren, your nieces and nephews, whoever it may be, they have a really fruitful conversation, because they can explain the benefits to them. Because here's the other really cool thing. I've got these trusts for my daughters, for example. So my daughters are 29 and 27, and my son's 4. As you can tell, that's from a second marriage. Just, you know, he wasn't a surprise which came along. Right? It wasn't just someone just came along as a bit of surprise. No, he was from the second marriage. But my children, my daughters from my first marriage, for 29 and 27. If I pass assets through into them, and then they want to pass assets down, that's fine. But now my daughter, Hope, for example, she can now use that trust herself. So her will should be written to take account of that trust, because she might want to push some assets up into that trust for the benefit of her children. And this is why having a trust is so powerful, because it can last over many, many generations. And if you set one of these things up, not only will your children benefit, but your grandchildren, your great-grandchildren, your great-great-grandchildren. And it has a whole host of benefits which your advisors can explain to you. So what actions should you take? Well, if we look at each of those 4 areas, the first one from capacity is that please make sure that you have both lasting powers of attorney set up. This is the property and affairs and the health and welfare. I really can't see any reason for not setting one of these up. I've got a question come up, and this is a question from Mike. So Mike says, is a lasting power of attorney different from an enduring power of attorney? Yes, Mike, has some similarities, but it's also very different. An enduring power of attorney is the predecessor to a lasting power of attorney, and it's a much weaker document. It really only deals with money. It's very difficult for an enduring power of attorney to deal with physical property. It certainly doesn't deal with things like nursing homes and dealing with things like the doctor and the pharmacist, that kind of thing. The other thing with enduring power of attorney is the registration of it. You know, you can only really, or you should only really register it when the person is incapacitated. The beauty of lasting powers of attorney is they can be registered the moment they're set up. And that means that when you set one of these things up, you sign it immediately, it should be registered with the Office of the Public Guardian. That means the moment you're incapacitated, let's say you're one of the very unlucky people that suddenly got this dreadful virus which is going around at the moment, you're stuck in hospital, immediately your children, your nieces and nephews, your best friends, whoever it may be, can deal with things on your behalf. I can't imagine how difficult it would be for someone if they were taken into hospital and they didn't have a lasting power of attorney that was registered. Just simple things will become such a daunting issue. And when you're ill, the last thing you want is to be worrying about financial matters. When you're ill, the last thing you want to be worried about is, can I get down to the pharmacy to pick up my own drugs, that kind of stuff. So I think everybody should have a lasting power of attorney, and it is a much more powerful document, Mike, than enduring powers of attorney. And simply, lasting power of attorney just overrides the enduring power of attorney. With regards to your will, please make sure you've drafted your will. All research shows about 60% of the population don't have a will. I don't understand why. It costs a few £100, something like that. So why not draft it? But for a lot of you, it's a question of redrafting your will. A lot of wills that we see really are out of date. I would say of the wills which I've seen, and in the last 4 or 5 years, 80% of them have got mistakes on there, or are out of date, or are unenforceable for a whole host of reasons. Signings can be wrong, there's a whole bunch of stuff. So my strong suggestion is, if you haven't already done it, if your will is certainly written more than 4 or 5 years ago, please have your advisor redraft the will. But if your advisor has never seen your will, please let them see a copy as soon as possible. They'll be able to tell you whether it needs to be amended or changed. Most of our advisors will do that for you without a payment. I'm sure they're quite happily to spend half an hour looking at the will for you. So I'm not speaking on their behalf, so they won't charge you, but most of them are reasonable people and will take a look at the will for you and then tell you what needs to be done. From an inheritance tax point of view, it's probably a great idea to meet with your advisor and plan what you're going to do. If you haven't done this, please do it. It's much easier to avoid inheritance tax while you're alive and you have capacity. Once you have incapacity, the curious thing is your powers of attorney, your attorneys, the people that you set up with your lasting powers of attorney, cannot do inheritance tax planning for you, because the thing with inheritance tax planning, it's not for your benefit, it's somebody else's benefit. So you have this issue here with regards to making sure that you do the inheritance tax planning before you are incapacitated. Now, David's come in and asked a question, what about witnessing? And this is a real issue at the moment. These documents do need to be witnessed, and you can't really do a virtual witnessing of a document, so they will need to be witnessed by somebody. Now, coincidentally, we had somebody 2 days ago who had a document, it was a trust document, needed witnessing, and so they had the document, and they were in the garden, and there was someone on the other side of the garden, the next door neighbour, and they signed the document, then they put it in a Tupperware box, it was, and they passed it over. The other person had hand gel, who through the hand gel opened the box and then signed it as a witness, put it back in the box, passed it back. The person with the hand gel opened it all again, then I had a signed document. So they are going to be need witnessing. Now, what happens if, say, you had a will and it wasn't witnessed? Well, it's then up to the court to decide whether or not that document was one which can be considered safe or not. And if you were to, let's say if I were to prepare a will for somebody and I post it to them, then I saw them read it on video and then signed it and sent it back to me, I could sign an affidavit saying that I'd saw them by video signing the will, and whilst that isn't witnessing it, it's, I would think, a fairly strong chance that the Court of Protection would accept that if I'd seen that. But these documents do need to be signed. Then lastly, how to deal with your beneficiaries. Well, it really depends if you want your beneficiaries to get what you pass down. the Beneficiary Protection Trust is a very, very strong document. Only last year I was in court where we had one where this money be passed down to the son, and he'd been made bankrupt, and the creditors were claiming the money which he'd inherited because his mum and dad had passed the money down to him during his lifetime. So they'd set up the trust and put the money into the Beneficiary Protection Trust, and this was a few hundred thousand pounds, and the creditors were claiming that money. But because the money had passed through a Beneficiary Protection Trust, the court threw the claim out by the creditors. So imagine that, if you've got anybody who's going to benefit, whether it's children, grandchildren, friends, or what have you, and they run their own business, especially in today's environment, think how many businesses are going to go bankrupt right now. I would be very surprised if there's not a massive increase in insolvency over the next 3, 4, 5, 6, 7 months. And so anybody who's passing anything to anybody who is self-employed or runs a business really should be making those gifts via Beneficiary Protection Trust. It will protect these things significantly, and they are very, very powerful documents. Now, I don't know how big a gift would be. I don't know how big your estate is, but if your estate's worth, I don't know, say £500,000, say £1 million, say £2 million, then the £1,000, £2,000, £3,000, £4,000 or so to put a Beneficiary Protection Trust in place is an insignificant amount compared to the amount that it saves. It really is. So there we are. I've already run well over my time of about 20-25 minutes. So I just want to ask, are there any other questions? If you do, if you could just type them up and I'll just quickly cover those for you. Okay, yes, there's one that's just come in about costs. So how much do these things cost? Well, I don't like the term how long is a piece of string, but how long is a piece of string? I mean, most wills will cost £200 or £300 of that kind of amount, probably a similar amount for lost in powers of attorney. With regards to trust and inheritance tax planning, that's really going to depend on the complexity, and each of your individual advisors will probably be able to give you a specific quote on costs. And there's 2 types of costs to bear in mind in here. Well, I guess 3 types. The first one is the cost of setting the things up. What's a check you're gonna have to write? The second thing is any cost in running these things. So if you have a complex trust, there might be some cost of running them. But the other cost is, what's the cost of not doing them? You know, sometimes we get wrapped up in, you know, how much is this going to cost? In fact, I was speaking to a client the other day, and the particular advisor asked us to speak to them. It was just on a technical point, but when I spoke to them, the advisor was setting up 4 powers of attorney, 2 for the mum and 2 for the dad, so health and welfare and property affairs for each. That was 4 of them, and his fee, the advisor's fee for doing this was £1,200. And they said to me, "Do you think this is a bit expensive? You know, these documents are, you know, something which he's done fairly quickly. Is it worth £1,200?" And I said to them, well, it's not really how long it takes him to do these. It's the knowledge and wisdom that he's built up over the last 20 years, which allows him to do this effectively and do it properly. Secondly, that allows him to certify, which, you know, is a hugely valuable thing at the moment. Normally your doctors are going to certify, and I'm telling you, no doctor is going to allow you into the surgery to certify a power of attorney at the moment, where your advisor can do. But also from a cost point of view, I said to the chap, "May I ask what car you drive?" He said, "Well, it's a Mercedes." And I said, "And how much do the tyres cost on this Mercedes?" He said, "Well, I don't know." I said, "Well, have a guess, you know, what sort of car is it?" And it was an SL something or other, so the sports car version, and they're low profile. And he said, "Well, probably about £300 each." I said, "So you'll happily buy 4 new tyres for the car, but you're worried about the same cost when it's going to protect everything that you have? I mean, everything. And more importantly, it's going to protect you if you end up going into a nursing home or you end up being incapacitated." I think that's actually cheaper, twice the price. It really is. So anyway, I'm going to, there was a couple more questions coming, but I'm going to speed on that. So what I don't want to do is overrun too much. I'm already at 40 minutes. Firstly, I'd like to thank you all for listening. I know it can be really difficult doing webinars because you're just hearing me trundle along while you've got the screens in front of you. I hope you found it useful. please take a few minutes to speak to your existing advisor on each of those 4 areas. I'm sure all of your advisors have got everything covered, but it might be just a case that for whatever reason you hadn't done the power of attorney, or it might just be that your beneficiaries weren't really organised correctly. And with that, just that short conversation with your advisor might make a big difference. So thanks very much for listening, and perhaps I'll get to speak to you again in the future. Thanks very much, everybody.